make any comments. So this is Kathleen Hayes, and this is officially my last meeting as chairperson of the council. We are calling the meeting to order at 5:05 p.m. It is May 18th, 2022. And the first agenda item is a supported decision-making presentation, which I'm happy to kind of jump right into, and hopefully people can that join can kind of pick up wherever I am. So let's see, I do have the share capability. Share. Okay. Now, PowerPoint. This is interesting. This has never been the way that the sharing comes up for me. So let me see. I don't see the presentation. Let me see. Well, let me just start clicking. So if I share this screen, can you see the presentation?
Yeah.
All right, and now it's full screen?
Yes.
Okay, perfect. All right, so the title of the presentation is The Spectrum of Decision Making. And this is a presentation that focuses primarily on when an individual with a disability turns 18, what decision-making tools are available to them to help them to support decisions that the individual is now making individually, or to enable the parents to continue supporting the child in making decisions, or in some cases, the parent making decisions on behalf of the child, or now the adult child. So the magic number here is 18. Prior to the age of 18, parents have the ability to make decisions for their kids because they're their natural guardians. And when a child turns 18, there is a legal barrier that forms between the parents and the child, regardless of an individual's capacity. So disability or not, the law presumes that when somebody's age 18, they're able to independently make decisions about their medical welfare, which is represented by the heart, their financial welfare, which is represented by the money, and for many people with disabilities, educational decision making. Now, in most cases, 18-year-olds aren't making good decisions no matter what, and really should still be hopefully getting some participation from others. Just one moment, I'm getting a call from my uncle. Oh, it's gone. I was getting a call from my uncle, who doesn't usually call me. So in any event, the individual is now in the ability, or has the ability to make decisions. So the question is, what can be done in terms of decision-making options for that individual once they turn 18 to enable the parents to help continuing to make decisions to the extent needed? So the principal first question is, well, why is it necessary for individuals with disabilities to use the least restrictive decision-making tools? Because tonight we're talking about a spectrum of options, which range from the least restrictive, meaning the individual with a disability is making the decision, to the most restrictive, meaning someone else is making a decision for that individual. And where we fall on that spectrum, the most appropriate tool for an individual is going to vary depending upon who that individual is and what their needs are. But what the law requires is that we look and evaluate from the least restrictive to the most restrictive options and not the other way around. So the question is, why is that? And this really goes to the principles of self-determination. And these principles are right from our DDS website, that people with disabilities have the right to control their lives and have authority over the resources that support them, which includes the freedom to decide how to live their lives, the authority to manage their resources and supports, the support that they need to fulfill their lives, to fulfill their personal goals and dreams, and to be able to have and take responsibility for their actions and decisions. So what does the law require it's really interesting because the ability to make decisions legally does not exist in a vacuum. And I think a lot of people don't realize that we naturally make decisions with reliance and support and guidance from other people. And our Connecticut laws specifically state that an individual is competent to make decisions if they can make those decisions independently, or if they can make decisions with assistance from family, friends, or other supports and resources. And the decisions that that person ultimately makes will avoid serious physical injury, illness, abuse, or financial harm. And it's important to focus on that serious element because there's another concept that goes hand in hand with self-determination, which is called dignity of risk. And that concept basically says that it's okay to make mistakes. It's okay to make bad decisions. And in fact, many times we get something from making a bad decision. We learn from our mistakes, we evolve, we become better. And people with disabilities are the same. So they should have the ability to make bad decisions, so to speak, and make mistakes and learn from them, just as people without disabilities have the ability to do so, within the limits of making sure that those bad decisions are not going to result in some serious physical or financial harm or abuse. So here's the spectrum of decision-making options. And as I mentioned, they go from the least restrictive to the most restrictive options. So we're going to start off by talking about each of these: advanced directives, power of attorneys, and supportive decision-making agreements. And then moving along in terms of tools that become a little bit more restrictive: voluntary conservatorship of person and estate. And then the most restrictive options: involuntary conservatorship of person or estate, or guardianship. And you'll notice with these little people images that the least restrictive option has one person because it's showing who's the one making the decision, and that's representative of the person with the disability. With the voluntary options in the middle of the spectrum, you see the individual is making a decision to appoint other people to make the decisions, hence the one person and the couple. And then the most restrictive option, the individual is not making the decision to appoint someone, nor are they making a decision as to their personal welfare or their financial decisions, depending upon what tool is in place. And feel free to ask me questions, by the way. Please feel free to jump in. I can't see at all of the squares, so you'll just have to maybe just put your question in the chat if you have one that comes up, and I can address it as we go. So advanced directives. This is the first stop in our spectrum of decision-making tools. This is a legal document that's created by an individual, and it really has to do with medical decision-making, nothing beyond that. And the way that this typically works is that someone with a disability would sign this legal document, appointing someone as their healthcare representative, and that representative is appointed to make decisions, medical decisions, on behalf of the individual with a disability, under generally two circumstances. One is if the individual is unable to make a decision, like with incapacity. So what that really looks like is somebody enters into this agreement having capacity to do so, and afterwards they have a traumatic brain injury or they're in a coma. So those would be circumstances where somebody has lost capacity, and now the healthcare representative is appointed and able to step in and make decisions based on what they believe or what they know that the individual would have wanted under those circumstances. Or, and this is the circumstance in which this advanced directive is really the most helpful for the group of people we're talking about, if the person requests assistance. So a healthcare representative can participate in medical decision-making, like doctor's appointments, that an individual that's 18, 19, 20 goes to. They can have their parent continue to participate in those appointments, to call and speak to a provider directly, to order or manage prescriptions, to make medical decisions about surgeries or different therapeutic interventions. So the individual essentially can defer to their healthcare representative and say, speak to this individual, they'll make the decision on my behalf. If there's a disagreement between the individual with a disability and their healthcare representative in terms of a particular decision to be made, let's say regarding a medication that's recommended, the person with a disability is always going to maintain their ability to make a decision. So you're not giving up authority by creating this document. You're really creating a safety net for yourself and a tool, a resource tool, so that if you lose capacity or if you simply want somebody else to participate in decision making, that you have that person appointed and that plan in place. All right. So next we have a power of attorney. So this is really the other side of the same coin as an advance directive. It is also a legal document created by an individual, but instead of pertaining to medical decision-making, it pertains to financial decisions, legal decisions, and educational decisions, which is really important for somebody that has an IEP or a 504 plan through the school. The way that this document works is that the individual will name an agent to make financial, legal, or educational decisions on their behalf. And really, it arises in the same circumstances as that healthcare directive. If the person loses capacity and can't make those decisions themselves, their agent will step in and make decisions on their behalf. Or if the person is requesting assistance. So if they say, I want you to go and manage that bank account on my behalf, you call the bank, you withdraw money for me, you set up the account, you participate in the PPT, I don't need to make decisions about my IEP. Those are the types of circumstances under which this power of attorney really has a lot of value. Just like with the advance directive, if there's a disagreement as to a decision with the individual and their parent or whomever they name as the agent, the individual's wishes are always going to win because this is a least restrictive tool. They're not giving up any sort of legal authority and they're staying in the driver's seat. Okay. I don't think there's any okay, there's no questions so far. All right. Supported decision making. This is a newer concept for many people, although I will say it is not new nationally or internationally. Supported decision-making first came around as a concept at the UN Convention for People with Disabilities in 2006. And the way in which it came up was the convention recognized that people with disabilities do not, by nature of their disability, lack capacity. So the fact that someone has a disability does not mean automatically that they don't have the ability to make decisions. And that was ratified by many countries. The US never ratified it, but our Bar Association recommended that we do so. And there's been a lot of proliferation, a lot of next steps that have taken place nationwide and internationally, as I mentioned, based on that concept. And supported decision-making really started to take root from 2006 following that convention. Supported decision-making, defined, is a collaborative process that promotes an individual's ability to make choices. So I like to reread that definition by taking out the word supported. Decision-making is a collaborative process that promotes an individual's ability to make choices. So if we think about the way that you and I make choices, if I need to make a financial choice, I might consult with a financial advisor. If I need to make a relationship decision, I might consult with friends or a therapist. If people need to make a legal decision, they consult with an attorney. And the fact that people need to consult with other people is what makes us human. It doesn't mean that we don't have the ability or the capacity to make choices. So the idea of supported decision-making is that someone with a disability is doing the exact same thing that everybody does. They just might need support in situations or circumstances where other people act independently. And the need for support in those other domains doesn't negate their ability to make choices. So supported decision-making is the process whereby an individual with a disability is working with other people, consulting with other people, a network of supports, and getting guidance and counsel and advice to help them to make an individual choice. Supported decision-making can be informal or formal. Informal supported decision-making is kind of what I just described. It's an organic reliance on the supports that you have in your life. So asking a parent or a friend or a therapist or a religious advisor for guidance with challenging life choices. So it's somebody that's just mapping out and saying, when these issues arise, these are the people that I'm going to go to for advice. Or supported decision-making can be formal, which means that the person can actually enter into a written document, similar to a power of attorney or a healthcare directive, identifying the areas where they need support and identifying the people who will provide the support, known as supporters. And those supporters can sign off saying, yes, I will be there to support you if a decision comes up that you need assistance with. Now, some states, and I think this might be my next slide. Yes, some states actually have laws in place that recognize supported decision-making agreements or that recognize supported decision-making as a concept. We don't have that yet in Connecticut. So what you'll see here in the dark green are all the states that have some form of supported decision-making legislation. And the light green states are states where there's supported decision-making legislation, but it's limited to organ transplants and non-discrimination in the organ transplant process, making sure that people are not discriminated against if they need support from other people in determining whether or not they want a transplant. The yellow states, are, which you'll see Connecticut is among, are the states that at some point have proposed supported decision-making legislation, but that it has not passed. So that was the case in Connecticut, I believe, in 2019. And that's what spurred a lot of activity and action in Connecticut itself among the Supported Decision-Making Coalition, of which I am a member, which is comprised of Disability Rights Connecticut, Legal Services, DD Council, many different DDS, many different stakeholders, agencies, nonprofits, private organizations dedicated to developing supported decision-making as a concept and maybe even ultimately proposing legislation of our own. And then the red states haven't done anything by way of legislation. But the fact that we don't have legislation on the books doesn't mean that we can't have formal supported decision-making agreements. It just means that if and when people do create formal written agreements, and I do this now for my clients, so it's not something we have to wait for down the line. Sometimes people don't know because they're not familiar with that document what exactly it means. So it's just important that there be education for that organization or that institution regarding what the decision-making agreement means and how it works. This is an example of a worksheet to help somebody to either come up with an informal supported decision-making network of supporters, or to help to tailor a formal supported decision-making agreement. So this would be something that someone with a disability would go through and decide where they can make decisions alone, where they need support, or where they totally need to defer to somebody else. And this obviously is going to be different for everybody. So no one supported decision-making agreement, formal or informal, would match another. These are just more examples of different domains. And of course, this is not exhaustive. It's tailored to everyone's personal needs. This is an example of a written agreement. And like I said, there is no form. There is no one right way to have an agreement. So you can create any type of agreement that you want. What it would traditionally include is an individual naming their supporters and identifying the areas they need support with, like making choices about food, medical decisions, where they work. And also I highlighted some of these forms because, as I mentioned, this agreement in itself might not be recognized by medical providers. It might not be recognized by schools because they're just simply not familiar with it. So it may be important to also attach all other authorizations like a HIPAA release for medical information or an educational release, so that there can be a sharing of educational records and things like that. The document would be signed by the person with the disability and also signed by people that agree to provide support. And one of the things you'll see in this consent of supporters is that the person is saying, my job is to support the person with the disability. My job is never to make a decision for them. So in this case, the individual can never actually just defer to a supporter. A supporter can never go and do something on behalf of the person with the disability. They always need to basically just be advising and counseling the individual, maybe even helping them to gather information or to weigh pros and cons, but they're not the one making the final decision. What I recommend for individuals that are considering supported decision making is that you create 3 documents: the power of attorney, the healthcare directive, and the supported decision making agreement. And the first 2 are really important because, number 1, we do have laws that recognize these documents on the books now. And number 2, those documents will survive in capacity. So as I mentioned, if someone's in a car accident or if they're unconscious, the individuals in those documents can continue to act on behalf of that individual, whereas that's not the case under a supported decision-making agreement. So if all the person has is a supported decision-making agreement and they lose capacity, their only option for other people to be able to make decisions for them is to go through the courts and to have a conservator or a guardian appointed. And I'm going to talk about those options next. So we are now in the middle of our spectrum. The first 3 documents that we talked about are legal documents. They don't involve a probate court. Voluntary conservatorship of person or estate involves the local probate court, so the court in the town where the individual is residing. Probate courts are usually in an individual's town hall. And voluntary conservatorship is a court order that names 1 or 2 people to make decisions on behalf of someone with a disability. Conservatorship of person is decisions about your personal welfare. So that's kind of similar to an advance directive. It's usually more oriented toward medical decision making, but it also includes where someone lives, what their educational program looks like, what their employment looks like, applying for public benefits in many cases. And conservatorship of estate has just to do with financial decisions. So the voluntary piece of this is that the person with a disability, let's say they turn 18 and they have a conversation with their parents and their parents say, okay, you can make these decisions, your medical decisions for yourself, educational decisions, or you can make those decisions with our support and we'll guide you and help you to make those decisions. And the individual, if they're able to express this, can say, I just don't feel comfortable and I'm not ready to make those decisions. I want you to have the total authority to make these decisions for me. So it's voluntary because the person with the disability is the one actually signing the forms for the court, requesting that the conservatorship be created. So usually they're naming their parents, and they would name them to be conservators of person, meaning just for personal welfare, or they could also name them to be conservators of person and estate for financial decisions, or just for financial decisions. So you can have a conservator of person, you can have a conservator of estate, or you can have both at the same time. So whose wishes win? Once a conservator is appointed, the court order is going to say who makes or what decisions the conservator makes. any decisions that aren't in that order, the person with the disability gets to keep making those decisions because they're not covered by the conservatorship. But as for those things that are in the court order, the individual has voluntarily given up their liberty rights to make those decisions. So if something comes up and there's a disagreement between the individual and their conservators, the conservators' wishes are going to win, which is the first time in our spectrum that that's been the case, and that's what makes this a more restrictive option than what we spoke about previously. However, because this conservatorship was created voluntarily, it can also be ended voluntarily, meaning that the person with the disability could write a letter to the court saying, I don't want this conservatorship anymore. It can be as simple as that. And 30 days later, the conservatorship will be ended and those liberty rights will vest back in the individual. All right, so now we're in the furthest end of the spectrum, which is involuntary conservatorship of person and estate. This is a court order naming one or two people to make decisions on behalf of an individual with a disability. And it's different from voluntary conservatorship because the person with a disability is not the one asking the court for the conservatorship. It's other people, which would usually be parents, asking the court to create the conservatorship. Involuntary does not mean that the individual with the disability disagrees with the conservatorship. Involuntary means that the person with the disability has been determined by the court to lack the capacity to be able to consent or to offer consent or to disagree with a conservatorship appointment. So there's a very high threshold for involuntary conservatorship because essentially the court is taking away somebody's liberty rights to make decisions without their input to a certain degree. So there's protections that the law puts in place in consideration of what's at stake, which is the stakes are high. So the individuals that wish to be appointed would submit a petition to the court saying we would like to be appointed as conservators of person, conservators of estate, or both. And that petition has to be accompanied by a physician's evaluation stating that the individual with a disability doesn't have the capacity to make their decisions for themselves, whether it's for medical welfare, finances, or both. And that's a probate form that you would give to the physician. And there's a lot of check boxes and ways for them to actually support with evidence and describe the ways in which the individual needs support. An attorney is appointed for the person with the disability, and that attorney's job is to represent the wishes of that individual, not the best interests. So that's a really critical difference, that if somebody would really benefit from having a conservator and really can't make decisions themselves, but that person says, I don't want conservatorship, the attorney's job is to represent what that individual wants. And then the petitioner's job, the parent's job, is to present medical evidence that convinces the court that conservatorship is necessary regardless of what the individual's personal input is. Also, a marshal will serve notice of the hearing to the person with the disability, so it's clear that they knew that there was going to be a hearing about their legal rights and they have the ability to prepare and participate. And lastly, for the court to issue conservatorship, they have to determine it's the least restrictive means of intervention, meaning that other options like a power of attorney, healthcare directive, or a supported decision-making agreement are not appropriate for this individual or would not be possible to protect their interests. In this case, the conservator's wishes win if there's any sort of disagreement between the individual and the parents or the conservators. And because it's involuntary, the person cannot simply send a letter to a court and end the conservatorship. They could petition the court to end the conservatorship with representation from their attorney, but they're going to have to prove that whatever circumstances existed to create the conservatorship are no longer the case to be able to undo the conservatorship. And it can be an uphill battle. Last but not least, we have guardianship, and guardianship pertains to people with intellectual disabilities only, which is defined in Connecticut as an IQ of 69 or lower that started before the age of 18, coupled with difficulty in carrying out various daily tasks. So this is really similar to involuntary conservatorship of person and estate, which usually, not always, but usually pertains to people with IQs of 70 or above. By and large, involuntary conservatorship and guardianship are two sides of the same coin. If someone's under guardianship versus involuntary conservatorship, the differences would be imperceptible in terms of what the person's role is as guardian versus conservator. So typically we're talking about the same types of powers and responsibilities, except for guardianship, there's no automatic right for the guardian to manage finances. So guardianship typically pertains to residence, educational decisions, employment, medical, personal care, or public benefit supports. My next slide talks about the financial component. So the way that this works is really similar to the involuntary conservatorship, but instead of having a physician's evaluation, DDS will complete a report basically saying that, yes, this individual meets our definition of intellectual disability and guardianship would be appropriate. An attorney is appointed for the individual, and likewise, they are still served notice by a marshal of the hearing. The guardian's wishes win if there's a disagreement between the individual and the guardians. And lastly, guardianship can include finances, as I mentioned, but only up to $10,000. This is a separate form that would have to be filed with the general guardianship petition. And if an individual has more than $10,000, then you would be applying for involuntary conservatorship of the state. One of the things that I talk about, though, is that I seldom find that I'm recommending that individuals have guardianship of a state or conservatorship of a state. And the reason is that there's a lot of other tools to be able to help someone manage their money that don't include this authority from the court. Because once you get this authority from the court, you now have to report to the court in terms of where every penny went. And once you're under the court's jurisdiction, this can be a lifelong reporting requirement, which can be a little bit burdensome and can also be costly because you have filing fees and things like that. So the ways that money can otherwise be managed would be, for example, Social Security can be managed by a representative payee without the need for a conservatorship of a state or guardianship with financial authority. Money might be in a special needs trust, in which case the trustee can manage the money. Money might be in an ABLE account where an authorized representative or parent can manage the money in that account. So I always say, let's look at exactly what the resources are. And if it's necessary, get the appropriate authority through the court. But to the extent possible, I always recommend those least restrictive options to keep people's lives simpler, but still functional in the way that they need to be. So this is a summary. We talked about the spectrum of decision making from the least restrictive to the most restrictive tools. The least restrictive tools being this trifecta that I recommend you get: the advanced directive for medical decision making, power of attorney for financial, legal, and educational decision making, and a supported decision making agreement for those areas, as well as anything in between: social supports, emotional supports, employment considerations that would be tailored to the individual's additional needs. And then we talked about going into the probate court voluntarily, somebody voluntarily giving up their rights and being able to undo that when they want to as well. And then we talked about involuntary proceedings whereby other people are getting authority on behalf of the person with a disability. And as I mentioned, we don't know where you stop along the spectrum because everybody's needs are different. But what's important and what the law requires is that we always start with the least restrictive options and evaluate them. And if they're appropriate, then that's where you stop. And if they're not appropriate, you need to be able to explain why they're not appropriate and move along to whatever the next appropriate option is for that individual. All right. I'm going to stop my screen share. Chat. All right, let's see. Sorry, I didn't get these notices. So Rick, what if two guardians or conservators disagree? That's a great question. So if there's a disagreement among the conservators or the guardians, they typically would have to go to the court to get some sort of decree or guidance in terms of the best decision. And in some cases, the court will appoint what's known as a guardian ad litem for the individual with a disability, and that GAL, as they call them, their role is to make decisions based on the individual's best interests. So whereas the person has a court-appointed attorney, the attorney's job is to represent what they want. The GAL's job is to represent what's best for them. So for example, I have a lot of clients that are divorced, that are co-guardians for their children, and they're just kind of hoping it keeps working. And in some cases, they need a GAL to help to break the tie when there's a disagreement.
Thank you.
You're welcome.
Very helpful.
You're welcome. All right, any other questions? Great. Well, thank you.
I think it was very well organized and clears up a lot of questions that have been floating around for a long time. Because you hear supportive decision making and you immediately cringe that, oh my God, what's going to happen? If we can already do this, what is the benefit of enacting legislation?
That's a great question. So I just gave this presentation to, or a version of it, to the elder law section of the bar. And education in itself is important, because if you don't really think about how decisions are made, it's kind of a philosophical concept. We automatically revert in default to, in many cases, the most restrictive option. So schools are saying, your child is turning 18, you need guardianship. So they're just defaulting to the most restrictive option, mostly because people are not aware of the other options that are available, including attorneys. So the first step is, or one of the first reasons is because it educates people and it gives legitimacy to the fact that relying on other people for support is a legitimate alternative to guardianship or conservatorship. And in terms of having a statute, it's the same thing. It gives legitimacy to the concept. Part of what I would like to see happen, and what many of those green states have done, regardless of whether we have a form, because I think a form would be nice, but a form also has, I think, some drawbacks because it becomes limited and it might become prescriptive, so that some people say, if this form doesn't apply to me, then I can't use supported decision making. So I think that has some limits that would need to be considered. But what many states have done, including the uniform law for guardianship, which a lot of states have turned to for their own guardianship statutes, is had a section that defines what supported decision making is. So basically, supported decision making is a collaborative process where people can rely on others for support. So it defines it. And then in the guardianship and the conservatorship statutes, it says prior to implementing guardianship or conservatorship, the court must find, by clear and convincing evidence, that lesser restrictive options such as powers of attorney, advance directives, supported decision-making agreements are not appropriate. So it puts supported decision-making right in the guardianship and conservatorship statutes, so that courts now are held to this standard of thinking about and considering whether or not this is a viable alternative, versus just saying, yeah, sounds about right, let's approve the petition. So just kind of putting more safeguards in place for individuals.
Thank you.
Mhm. Adriana, it looks like you're typing.
Sorry, I could talk for a second. I was just curious. Great presentation. Thank you, Kathleen.
Oh, you're welcome.
Can you help me understand plenary guardian and limited guardian?
Sure. So when you look at a guardianship decree, plenary guardianship basically is there's a bunch of areas in which an individual could need support on the guardianship form, like residence, education, employment. So a plenary guardian is when all those boxes are checked, meaning that the individual needs support in every domain that guardianship covers, whereas limited guardianship says, well, this individual can make their own employment decisions, but they need support making medical decisions. So a limited guardianship is limiting the authority that the guardian is given, whereas a plenary guardianship grants the guardian the full authority that the law gives a guardian.
Thank you. So when someone's applying for guardianship, they have to distinguish between which type. Okay, that's good to know.
Yes, yep, and it's right there in the form. It asks whether or not what you're applying for, and it has all the check boxes so that you go through, and if the person hasn't checked all the boxes, then that's naturally going to be a limited guardianship.
Perfect. Thank you.
You're welcome. Annette?
Hi, Kathleen. That was a great presentation. Thank you very much. So if we wanted to switch to decision-making and stop the guardianship, how do we go about that?
The way I'd recommend doing that is every year you fill out your guardianship report, and at the end it says, in your opinion, the guardianship should be continued, modified, or terminated. So you can pull up that form. You don't necessarily have to wait for the year to be up, and input that you want it to be terminated and the reason why. And then I would also recommend contacting the court-appointed attorney for the individual and letting them know we're looking to terminate this is why, so that everybody's on the same page. And then you'd have a hearing where basically you'd say, we found a lesser restrictive alternative that we want to try. This is what it is. Everyone's on board. And I wouldn't see it. A judge would really be, unless they're not convinced, a judge really has to approve that because they have to approve the least restrictive options for people.
Okay, thank you very much.
You're welcome. All right, any other questions? Okay, thank you. So next on our agenda, we have the approval of the minutes, which Claudia circulated. These are from our April 20th meeting. Is there a motion to approve the minutes?
I approve.
Okay, Annette moved to approve the minutes. Can somebody please second? Tammy, thank you. Second. All right, all those in favor, if you could raise your hand. Okay. All right, so the minutes are, and I'll just say, Don, I know you're not on camera. I'm assuming that, are there any abstentions or any people that disapprove of the minutes? Okay, perfect. All right, so the minutes are approved. And next on our agenda, we have the legislative update. And I did see that Claudia sent an email from Kevin Bronson, which I believe contains the relevant legislation that's been passed.
Gotta cook this stuff first.
I'm sorry? Oh, okay. All right, I haven't had the chance to look through each of these bills. The one that I can speak to, because I was aware of it with the elder law section, is an act concerning state agency compliance with probate court orders. And that legislation basically says that anytime there's any sort of legislation, not legislation, any issue that goes before a probate court that has to do with an agency, like for example, Medicaid services, I suppose DDS services as well. If there's an issue presented to a probate court, the state agency has to be given notice of that hearing, and they have the opportunity to participate in the hearing and to object. And what the probate court does is they make a decision. This legislation says that state agencies need to comply with the court orders that would pertain to their services. So up until this point, the probate court, you could give notice to a state agency. They might not come to the hearing or say anything about what the issue is. The court will issue an order, and then the agency might come back and make a different decision. And so the intent of this legislation is basically to align everybody, make sure that agencies are participating in the hearing so that when an order is issued, it is binding and not something that could be overturned by an agency later. So it gives a little more finality and clout to those probate court judges' decisions. So that was the piece of legislation I'm familiar with. Does anybody have any insight on the other statutes that were passed?
I'm familiar with the pieces that went into SB 369, and for the most part, they are pretty much routine changes. The one that I recall most vividly is that in the event that a representative, such as a guardian or conservator, or supported decision maker, or the individual is not available to consent to a surgery, the commissioner now has the authority to sign on behalf of the individual. But it's an emergency use situation, not just a general thing. That is the one that I recall. The budget worked out very well for the department and for families. And I haven't written up something yet, nor have I seen anything written up yet, but I will check around, and if I have something, I will send it out to the council. The only other thing I will mention, and I only really became aware of it because I was contacted by someone who's having this issue right now, and that is two senators in Washington from Ohio. The two senators, Portman and Sherrod Brown, have introduced legislation numbered SB 2065, and that will liberalize the rules for recipients of SSI. There are income and asset limitations for SSI. Some of the Connecticut restrictions are even more restrictive than the federal ones. And these two senators, on a bipartisan basis, would like to see those limits changed. And the family that contacted me is having a major issue right now with that. And they don't understand why they may have to pay back some benefits and so forth. So it's not an issue I have personal experience with, since my son has received SSDI ever since he was very young, and relatively young. He's 39 now. So, but I know this is a problem for some families. So it's in the Senate, hasn't really gone anywhere yet, but I think it's something that would be helpful to many families. Because SSI puts you well under the poverty level. And if an individual goes out to work and is capable of working, they basically are income restricted, so that it does affect their benefits if they are substantially employed, and not in like a I'll say a workshop situation, you know, a limited work situation, for lack of a better term.
Thanks, Rick. Anyone else have any legislative feedback? Okay. So next up, Stacy, we have your update.
Hi, this is Stacy Silva Gordon, Regional Director. I only have a few items. Number one, I just wanted to pass along that the region is looking for any parents that would like to participate in the Human Rights Committee, reviewing requests that are sent in from the private providers. The committee, they meet the second Thursday of every month, and the next meeting is June 9th. But if there's any parent that is interested on this committee, or if you know of any parents that have the time or that would like to participate, I'm going to give you Serge Walker's number, and he can be reached at 860-263-2469. Again, that's 860-263-2469. And his name is Serge Walker, who chairs the Human Rights Committee, HRC. The other thing I just wanted to share was recently a memo went out to the qualified providers. I believe it was May 10th, and we're increasing the rate for compensation for individualized home supports, also known as IHS, and personal support. So that's being effective as of May 1st. And so far, you know, the provider community, you know, has been asking for this and are very, you know, happy with this increase. So it will, you know, we're trying to help the stability of the IHS program. So that was good news. And also currently at this time, the regions were working on the national core, well, the whole state of our department, we're working on the national core indicators. And those are surveys that are being conducted with individuals to just measure, you know, how well we're doing with providing services to individuals. And it's a great way for us to see year to year how we're doing. So that's underway. And I look forward to, you know, when we complete that project and see what the results are so that we can share them. And that's all I have.
I have a question.
Yes.
Yes, Donna.
Donna Clausen. My question is this: it's well and good they're increasing what they're doing for in-home supports and other programs. When are they going to do something about transportation where individual trips are flat funded? Because they haven't got an increase in forever, and clearly the price of gas has gone up exponentially. So, you know, I'm in a situation where someone provides a ride for my daughter, and it's at a flat rate to drop her off for work, but they haven't increased that amount, and I know it's costing a whole lot more for the gas. So I wonder if anything's being done to address that.
I can bring that back. I'm sure that, you know, we are looking at a number of these concerns, and especially transportation. Transportation is a big concern. So I will bring that back and I can report our next meeting.
Because she falls under a unique one where they don't pay actual mileage because of the way it's done. It's per trip. So it really needs to be adjusted at some point soon, I would hope. Thank you.
Yes.
I'd also like to ask a question. You mentioned IHS for the providers. What about IHS for self-determination? Is there an increase in that as well?
Yes. Yes, there is.
And where would we find out more about that? Through a case manager?
Yes, I believe that we did share that information with case management as well.
Okay, so I'd need to find out from them about that.
If not, you can give me a call.
Okay,
I believe
great,
the
thank
memo
you.
was shared as well. You're muted. Okay. Kathleen, you're muted.
I'm sorry, I said, Annette, did you have a question?
Yes, what is the pay increase?
It's a 10% hourly wage increase for the employee.
Thank you.
Any other questions? Yes, Rick?
I know CFC runs under DSS. Does that increase also apply to CFC program services?
That's a great question, and unfortunately, I'm not sure. I would have to get that answer and report back.
Okay, thank you.
I'm going to assume not. This is Kathleen, because CFC is budget driven and families can create their own hourly rate based upon whatever budget they're allocated. So I would assume that it would be separate, but certainly I'd defer to whatever Stacy uncovers. Donna, yes?
Well, I know that some of our providers say they're getting a $1 an hour raise. I believe it's July 1st, and next year another $1 an hour already for community first choice. So I don't know if they've already taken care of that, but I know they're getting increases.
Oh, so maybe they're increasing the budgets in some way. Interesting. All right, anybody else? Okay. So next up are nominations for the chairperson. Does anybody have anyone they'd like to nominate? You can nominate yourself if you would like.
Rick, would you be interested in taking the position again?
I guess I would consider it on a short-term basis. I am very consumed with the council, DS council. We have a couple of special projects going on. So, and my son is having some issues with his transplant. So I would consider taking it on a short-term basis.
Okay, thank you. I nominate him if he's willing. If he's willing.
Here, I thought I retired. I thought Kathleen would come on board and we'd be set for a long time.
All set. Claudia, what is the process? So if we have a nomination, I don't even know if we have a quorum tonight to be able to vote.
I don't think we have a quorum. And that is typically just the process. I mean, we've just voted, we've done the nominations and taken a vote. It's not really a more formal process than that, but we do have to have a quorum. And I do also want to say, if regarding the rest of the membership, most of the appointments now have expired, those original appointment letters. If everyone is still interested in continuing, if you could just send me an email saying that, just so I can have the reappointment letters. By statute, you're supposed to only serve 2 terms and then take a break, but unless there's no one else waiting to join. So we're fine with that, but I do have to have them re-sign the appointment letters if everyone wishes to continue. So if you could just send me an email and I will send them to the commissioner's office.
Just a question on that, Claudia. Do we have open positions?
I believe there was 1 open vacancy.
Okay.
And I do know that Melissa Cruz, who's been attending, she's not here tonight, but she did send interest, saying that she would be interested. So we were going to recommend her.
Okay.
And I don't think it's more, we have to have at least 10. I think we can have more than that. So, as long as, but I don't think we have the 10 full vacancies.
Okay. So Adriana, I know you've come to several of our meetings. If that was something that you were interested in becoming a formal member of the council, you certainly can reach out to Claudia to let her know your interest in doing that.
Oh, thank you.
Donna?
Do we have a written guideline that says that we have to have somebody that's president or head of our group
Yes.
in the bylaws somewhere?
Yes, in the
But
statute there you have to,
First joined. at least
yeah,
for-
the statute specifies
or
that
that-
you have to have a chairperson, a vice chair, a secretary, and a treasurer, which we haven't really, we appoint somebody, but
Money.
yeah, we haven't had any yet. So yes, there are specific, those 4 positions have to be filled.
So Rick, you mentioned that you'd be interested on a temporary basis. What does that look like for you?
Well, our next election would normally be the end of this year. So after this meeting, we go on hiatus for a few months. So I'd say until the next election, I would be able to do that.
Until September, you mean?
Well, until the next election in December or whenever
December.
we have it. Yeah. So.
Okay.
Actually, we don't meet in December, so it would be the first one in
uh,
January.
Right.
Okay. All right. All right, so it's something that we need to continue to consider. Thank you, Rick, for your willingness to go back to the helm in the interim. And my 2 cents is I think we have a really dedicated core group. So Annette, Donna, Tammy, Lori, I think everyone would bring value to the position. Speaking of Tammy. So that's just my 2 cents. Tammy, we were just talking about nominations for chair, and Rick has agreed to come on an interim basis until January. And I just said my 2 cents is prospectively that we have a strong core group and that yourself, Annette, Donna, Lori, the other Donna, I think anybody would be an excellent choice. So that's just my feedback. All right, anything else on the nomination front? Okay, so now we have an open forum for public participation. Does anyone have anything they wanted to bring forward? Rick?
Tomorrow evening at 6:30, the Litchfield Arc is having a webinar for an hour on the autism waiver. That is a mystery that many people ask about all the time. It affects those who are over 69 in IQ and need support. And I know a couple of people who have been in that program, and it's worked out very, very well for them. So it's on their Facebook page where the Litchfield Arc. They have a special autism group that meets periodically, and I think it starts at 6 or 6 o'clock tomorrow night.
Thank you. Anyone else have anything? Donna?
Yeah, in light of the all the retirements and people leaving state service, and I know it's a significant problem in the South region. How is the North region doing with coverage for group homes, et cetera, and programs?
This is Stacy Silva, the regional director. We have been, it's been a strain on the private providers. It's been a big strain. A week doesn't go by where executive director isn't calling with concerns of, going down to minimum complement of staffing. Or struggling to find staffing, or looking to call temporary agencies in trying to get staffing. So it has been really challenging, but we've been just having conversations and making recommendations and trying to help agencies make it through.
Anybody else? Yes, Adriana?
Hi, I just wanted to share some things that Connecticut Family Support Network is doing. They're currently virtually on May 26th. We're partnering with self-advocate coordinators of DDS and doing a workshop, Mind, Body, and Healthy Tips via Zoom at 10 a.m. We are also on, apologize, this one is not virtual. It's actually the next one I'm talking about, May 26th. We're doing a medical home bilingual workshop in Norwich with UFS from 6 to 7:30. On May 25th, we're doing a Zoom from 6 to 7, prepare for the college transition in collaboration with Jennifer Sullivan. And then we have our West Region One Voice Conference on May 25th over at Ed Advance in Litchfield. We are also having a One Voice Conference in Norwich on June 16th from 11 to 1. We are having another One Voice Conference in West Haven on June 11th. And then we're having a Spanish One Voice Conference in Hartford Public Library from 11 to 1. And if anybody would like any flyers or information, I think there might be a couple other events. There's some Spanish events that I didn't mention. I have the dates on the top of my head. Feel free and I can send it to everyone. And most of our events right now are virtual, except for the One Voice Conference or small regional events where we can have that parent connection and networking. Thank you.
Great. All right, anything else for the group? Okay, so I think that brings us to the conclusion of the meeting and of our year. So everyone have a lovely summer. I know we do have to formally conclude the meeting, but you know, I hope everybody has a healthy, safe summer, and we'll get back together in, is it September? Okay.
Yes.
Good.
Kathleen, good luck with everything. Let
Thank
us
you.
know.
Yes, good luck to you and thank you for your service.
Thank you for
Congratulations.
Send us an
everything.
update.
Yeah, keep us
Mhm.
updated.
I will. I'll send a picture. I'll probably send a lot of pictures.
That's great.
Congratulations. We're so happy for you.
Thank you so much.
Great summer.
Everybody have a great summer.
All right, can I get a motion to adjourn?
So move.
A second?
Second.
All right, any opposed? All right, have a great evening, everybody. Thank you.
Bye-bye.
Bye-bye.
All right,
Bye.
bye.